One.
Hello, everybody, and welcome to the Daily Objective brought to you by the Ayn Rand Center UK, where we talk about all things current events and even outside the spectrum of current events from an objectivist point of view. Today, we have a very interesting topic with respect to Texas. Any freedom-minded person who's thinking Texas is one of the places that you should go to, hold on to whatever liberties you still have left. You might want to check that at the door for a minute and listen to this conversation, because it may go in directions that will make you change your mind. Even though Texas now, it seems like Austin is sort of a home. It's the second Gulch out there. Maybe they can change things. Anyway, to help me grapple with this issue that's happening in Texas right now, that's becoming a national problem, my favorite prosecutor, James Valliant, is going to help unpack all the craziness that's happening, put it into some perspective, and help us carry on the banner of liberty wherever we can. How you doing, James?
I am doing spectacularly well, as I usually am. I hope you are in the same situation, sir.
I'm good. I'm a little sweaty and verklempt after a jiu-jitsu workout. I went straight from jiu-jitsu to here. But so a federal judge in Texas has apparently made a ruling that affects women and I think affects men all over the country. Can you unpack this a little bit for us?
Okay, the decision that it's a federal judge in Texas who made a ruling about the FDA's approval of the abortion pill. 20 years ago, the Food and Drug Administration, just 20 years ago, the Food and Drug Administration approved the abortion pill, a pill that you can take after unprotected sex, and that can work for weeks after the intercourse occurred, the potential conception occurred. Believe it or not, about half of all abortions in America, I think a little over half of all abortions in America, are not done by going to a clinic and getting a traditional abortion, but by women simply taking this what's called the morning after pill. There is a statute of limitations on when you can bring a complaint against an FDA approval, and that long ago passed. But using the recent changes, because of the Dobbs case, the FDA modified its rules about the abortion pill. Using that modification, the federal judge then uses as an excuse to jump in, ignore that statute of limitations, and then say, well, the FDA didn't take into account the psychological impacts. Well, wait, the FDA never takes into account psychological impacts when it approves a medication. It's saying whether it's safe and effective. Now, obviously, as objectivists, we don't think there should be a Food and Drug Administration. They do not determine, in fact, many times whether a drug is safe and effective. And as they're deciding it, oftentimes safe and effective drugs are prevented from saving lives. So I call it the Federal Death Administration. In any case, the FDA, being a federal agency, its rules sort of supersede state rules. And what this federal judge has said is, in effect, no, we have to suspend anyone in the country having access to this pill because the FDA screwed up in the way it approved it 20 years ago. Now, presumably the FDA can go back through a process of approval that would somehow meet the standard or meet a better standard than this judge probably laid out, like psychological effects and stuff. I think that the federal courts are going to correct him on that aspect, if I had to guess. Given our current Supreme Court, I'm not so sure ultimately how they would decide it. I think that is a matter of open question. In my mind, though, it's a no-brainer. The federal judge has simply stretched the law beyond its intended purpose. You cannot use this modification, which is not related to what he said the flaw was, to reopen this case that has long ago been settled. Now, there's another case, a federal judge in Washington, in light of all this, has said, no. You cannot, the FDA cannot suspend or in fact change any of the existing rules about the morning after pill. So you've got leftists who are saying that in effect, the FDA can't change any of its existing rules because that would be a change in the status quo. And you've got conservative, let me put it, litigants and judges who are saying that no, the FDA completely screwed up. So we now have to reconsider the abortion pill, even though it was approved by the FDA 20 years ago. Make sense?
Yes. Well, it makes as much sense as the tribal wars in pretty much every other topic.
That's the best I can do, I'm afraid.
Very good. It's a very good framing. So does this have the force of law now? Do they have to remove these things from the shelves until this is resolved by the Supreme Court?
Even the Texas judge gave the federal government 7 days to respond. And Merrick Garland, the federal attorney general, has said, we are going to respond. And I think they will respond aggressively. And there are a number of grounds, as I've indicated, I think, on which a successful rational challenge to the Texas judge's rule can be found. And I'm hoping that even with our conservative Supreme Court, they would see that the Texas judge simply is not following the letter or the spirit of the law. Unfortunately, we're stuck with laws that I don't always approve of. As I say, the whole FDA scheme is something I don't approve of. But given existing law, I think the Texas judge did screw up, and existing law should allow the FDA's 20-year-old approval here to stand. But in the meantime, if some higher, because it'll go to the Fifth Circuit Federal Court of Appeals, and if they don't overturn this district court's ruling based on what the Biden administration says within the next 7 days, then yeah, it'll be a nationwide ban on this pill.
Until it's resolved by the Supreme Court.
Until it gets higher resolution, because now we're going to have a conflict between circuits. The Western Circuit is now going to be in conflict with the Fifth Circuit, which controls Texas. And that's exactly the situation where the Supreme Court will take up the case, because there's a conflict on especially on a basic rights issue or a legal procedure issue of this kind. When there's a conflict between the circuits, the Supreme Court will resolve the matter, so there's a uniform law throughout the country. And this is urgent that the Supreme Court do that, should these competing circuits have that. But as I say, it could be that the Fifth Circuit will overrule this judge. There won't be a competition between the circuits. But I think even what the Washington case said will probably need some higher review of it. The Dobbs decision has put us in a confused world. To what extent can the states, as the Supreme Court has said, ban, regulate, eliminate abortion within their states? That would put it, of course, in conflict with a federal agency, which normally takes precedent over matters about which it regulates, such as medicines, things like the abortion pill. So we are headed for a big, fat, juicy conflict in the Supreme Court. I wish I could predict it with clarity, but I can't, even though it seems to me that existing law would favor overturning what the Texas judge did here.
Now, it seems like abortion is one of those vortexes where reason is left behind. You get sucked into a realm of total irrationality. We have a Supreme Court now that you'd think tends towards originalism, or at least being constitutional conservatives, in the sense that they want to stick to the law as it's written in the Constitution. But now we've got this abortion thing, which many of those very same people are morally against, and which could cause some deep confusion in them. I don't know if they will be, if they have the moral philosophy to resist what this federal judge in Texas is putting out there. What do you think?
No, I think they not only don't have the moral philosophy, they're talking out of both sides of their mouth as necessary to get the end result that they're looking for. So it's solid legal pragmatism on the left. It's not going to be consistent, principled in any way. They want a certain result, and they will cut a path through the law, to use a phrase we used last time, to get that result at any cost. And that is the normal left-wing approach, you see, because we have a living, breathing Constitution that can mean anything we want it to mean from circumstance to circumstance. A thoroughly subjectivist, as objectivists, we'd call that a subjectivist approach to the law. Whereas our conservatives over here are intrinsicists. If it wasn't in the mind of the framers at the time, it cannot be included in what we call a right. It must be interpreted in the way that a late 18th century American lawyer would have understood it within that range. And of course, that's nonsense as well, and violates the original. By the way, the conservatives are violating the original intent of the framers in so doing. It's really quite straightforward here. They're both wrong. They're both wrong. The framers, in fact, both are embodying, in effect, the twin nightmares, each part of the twin nightmares of the framers. They did not want the rights to be read narrowly. They wanted the Bill of Rights to be read expansively. And so they spoke in big, broad language, freedom of speech, freedom of religion. And just to make sure everyone got it, they said, we're not done listing the rights. Just because we have enumerated certain rights in this Bill of Rights doesn't mean that the courts can deny or disparage others. So your freedom is the open-ended thing. The rights are the big, broad, open-ended thing. And then the powers, which they spent with. The president takes office on noon on the 20th day of January every 4 years. Okay, now that is a very specific thing and is to be read very, very narrowly. So when it comes to procedures and the powers of the state, it should be read very narrowly. And just to make sure that they got the point, the framers gave us the 10th Amendment that said the powers not given to the federal government are reserved to the states or the people themselves. So ignoring altogether that key code, which is the 9th and 10th Amendments, apart from the actual language and philosophy of these people, and the debates that you can read about this very issue in the Federalist paper, despite all of that, our current conservatives and our current liberals insist on taking each side that would have been the one of the two different sides that the framers of the Constitution were opposed to and would find a nightmare.
If only the framers
summarize it that simply.
If only the framers could have framed the arguments the founders could have framed the arguments in such an articulate way as to say we're avoiding intrinsicism and subjectivism at the same time. That would have been, I think, a much more helpful guide for us in the future. But objectivists are doing that, and I think that's an important signpost for people. Real quickly, before we get into this concept of states' rights and the federal government who has jurisdiction over what, I have some super chats here. Jason Adams, matters pertaining to objectivist at $1.99. I guess that was relative to my commentary in the very beginning. Yes, everything is a matter that comes under the umbrella of objectivism, I think. Jonathan Honig with $3.99. Thanks, Jonathan, for tuning in. Catherine for $4.99. The bigger issue, aside from this case, is the ongoing attack on reproductive rights. I would go even further. I don't like narrowly interpret rights as some people do. I think Rand, one of the reasons Rand didn't support Ronald Reagan was because he was anti-abortion, and she felt if you're anti-abortion, you're anti-choice, you're anti-life, you're anti the right to your life, which is a fundamental concept. It's not just reproductive rights, it's the right to your life, which is founded upon your free choice, your ability to choose.
Our framers understood rights as a unity, as a single unity. Right. And unfortunately, what's happened is in modern times, we think of the freedom of speech, freedom of religion, your right to, be charged, know the charges against you and stuff in the Sixth Amendment. We think of them as separate and competing rights. And the Supreme Court has permitted us to think of them in that way. That is not the way the framers looked at it, and it is certainly not the way objectivists look at it. Rights have to be considered as a whole, each in light of the other. Your freedom of religion, if you are an Aztec who believes in human sacrifice, doesn't give you the right to go murder children. Your freedom right, in other words, all rights have to be understood in light of every other right.
Right. And the basic right of the right to your life.
That's where it all comes from. Yes, sir.
Mary Aline with $4. Thank you always for your support. Ashley Shrug for $4.99. Plan B is so important to women, whether you made a poor decision or were assaulted. This will lead to women going underground and being hurt or killed. Absolutely, Ashley. I think this is a terrible thing. And look, when Texas passed the abortion law that they passed, I crossed it off my list as one of the potential places to one of the safe harbors out of California, because California is sinking into the Pacific Ocean as we speak. But now that this is happening, it makes it even less of a safe harbor for me, because this is a fundamental denial of the right to life, and it pisses me the fuck off.
It is. This is a little more than some minor traffic infraction or something that you might disagree with, or we're talking about a person's whole life, a woman's entire life, the control of her body. In my view, it's like military conscription. If you think that you can force a woman to have a baby, if you think you can force someone to go fight a war overseas for you against his or her will, then you are in effect advocating a kind of slavery, at least a kind of ownership over that person's whole life. It is fundamental in my view. Yeah.
Agreed, and that's why the Republicans are not the conservers of classical liberalism or rights as objectivists would define it. Catherine wants to redefine things here for 499. I said reproductive rights because that is what we were talking about at the time. That's true, but we're also talking about something broader. I just want you to know, objectivists.
Let me pick up on something Catherine said, though. I think that Republicans are committing hara-kiri here. I think they really are committing suicide. I mean, you look at what just happened in Wisconsin. The voters voted for some pretty tough crime measures and some, they seemed in other ways not to be a problem from, a Republican standpoint, but by 10 points, they gave the liberals the Supreme Court in Wisconsin.
Mm-hmm.
Why? Abortion, specifically over abortion. So if a swing state like Wisconsin, which seemed to be leaning right, can say, give a big fat raspberry to the Republicans on abortion, I would urge all of the Republicans out there to think very carefully about their dogmatic stance on abortion. Most Americans are in favor of legal abortion, and most Americans are really in favor of this abortion pill. So if you guys aren't willing to accept any kind, you guys are going to go down with the ship for your dogmatic belief that any abortion from the moment of conception forward is murder. You're going to be killing your party. You're going to be killing your party, GOP. And I would just urge you to stop with your dogmatic stance on abortion and allow pro-choice Republicans to have some breathing air in your party. If you want, that is to say, if you wanted to have a political future.
Yeah, but dogma is the title of both tribes' biographies. If you want my opinion, I don't think they're going to back off that anytime soon. It's been too central an issue. Christian ethics and the Christian religion is too deeply embedded now in conservatism to go back. Right? They're not. They deny the value of secular government. They deny the value of secularism. They think it's a moral vacuum. They're trying to institute their ethics in our politics. I don't think we can win against them.
And in so demanding religion be part of our constitutional analysis, they are violating the very words and intent of the framers. They are being as anti-originalist, whatever the terminology they use, they're being as anti-originalist as you could possibly be. It was the express intent of the framers to create a secular government. Secular government, period. And if they can understand that, embrace that, grasp that, then they are the enemies of the founding fathers. Much worse in a sense, because they're misrepresenting at least the lefties say we can't be wedded to the dictates of the founding fathers. The right is actually lying about what the founding fathers were all about. And that, in effect, is worse because they're destroying the rational alternative that was Madison, Jefferson, and company.
Well, again, we have the false alternative of they're gods that gave us wisdom that we can't depart from in any respect. And the other side of the coin, from the left's point of view, no, they're psychopathic slaveocracy that shouldn't be listened to at all. We have to discard everything that they say. Now, I was just working on the set with somebody who said we have to discard everything Jefferson brought to the world, including the Declaration of Independence, because he was a slave owner.
Well, we'd have to reimpose slavery. Jefferson was one of the 4 or 5 people in history that had more to do with the end of slavery in the civilized world than anyone else. But for the ideas that men like John Locke and his great enactor, Thomas Jefferson, put forward, we might still have slavery. It was the idea of individual property rights from the Enlightenment, which alone could end slavery.
Indeed.
No, what our leftist friends want to do is go back to some other form of collectivized slavery. And that's what the motivation of getting rid of Jefferson is. If you don't see the difference between voluntary employment and slavery, which Marxists do not.
They do not.
If employment is just a form of slavery, then what they're advocating is going back to slavery. So it makes perfect sense to me that one of the greatest people who eliminated slavery in history should be their enemy. Because they are, in fact, advocates of slavery.
there is actually a historical school called the New History of Capitalism, which attempts to prove Marx's thesis that capitalism is dependent upon slavery. And they do a very bad job of it. It's just that it's being taught in schools all over the country.
No, capitalism is what destroyed slave. It's funny. You think about a Enlightenment philosopher like John Locke. He was the first person to give really good secular philosophical arguments against slavery. He was also the guy who gave the first good secular arguments for individual property rights. The two go hand in hand. You cannot eliminate an appreciation for individual property. In fact, any attempt to go against individual property rights to that extent is advocating a form of slavery.
Indeed. And might I add that in our country, even in colonial times, the Quakers were one of the first abolitionists, but it wasn't until the Declaration of Independence came out that I believe 6 states made slavery illegal and started a wave of what they call manumissions, which were voluntary freeing of slaves throughout the entire country, and in fact through the South too. And the South was so frightened of the manumissions that they started in the early 1800s to crack down on these private manumissions as a social service, because as every overreach of government power does, they try to do it for your own good. And so supposedly slaves were being sloughed off into the free market, who were not prepared, who were too old or sick or lame, who became a public liability. So the legislatures, like in South Carolina, made it impossible for you to free your slave without legislative approval. So you had to pass a permit onto them, and 95% of the time, unless you did something extremely heroic as a Black person, you would be enslaved. They would not approve of that manumission. Mary Aline for $2, a pox in both their houses, Republicans and Dems. Yes, but you know where there shouldn't be a pox? On the American Capitalist Party. So I recommend somebody in some locale somewhere pick up that platform and run for local office, and we can start insinuating our ideas into the political world. So let's talk about for a second this states' powers versus federal powers here. Where do you stand on this? Because the conservatives are like, states' rights, states become the dictators. Not just that you have the local right to govern yourself, and the federal government sort of loosely oversees other things, and that most of the power belongs to the individual. They claim the states have these wide powers that essentially take over for the federal government. So they maybe should, be the ones that take care of our schooling and our health care and all that other stuff. They cede that territory to the statists still. But what is this thing about enumerated powers, state powers, federal powers? How can we make sense of this from an objectivist point of view?
Anytime someone uses a concept like states' rights, it reminds me of things like, the divine right of kings. Because there's really, when you use the word right, that doesn't mean you're using it in anything like a coherent, rational, reality-based sense. My right, states cannot have rights, groups cannot have rights, kings do not have rights, only individuals have rights, and only insofar as they are human agents. And therefore, the entire concept of state rights is a corruption. A total corruption. Only individuals can have rights if the concept of rights has any meaning and is objective. Now, legally speaking, historically, although most of the founding fathers opposed slavery, Benjamin Franklin, for example, started an anti-slavery league. Thomas Jefferson wanted slavery abolished in the Declaration of Independence.
Not only that, but before then too, I think he initiated 4 pieces of legislation in the House of Burgesses in Virginia to try to get slavery out of the colony of Virginia, and was summarily turned down by George III.
But the ideas he put in the Declaration undermined the entire institution, all men being created equal. And that was exactly the justification Lincoln used during the Civil War when he did abolish slavery. He quoted the Declaration. So, but John Adams, of course, and his son fought in court and out of court. The northern states at the time of during and after the Revolution were some of the first governments in all of history anywhere to abolish slavery. In any case, that context. In any case, to get the Constitution passed, they had to allow slavery in the southern states. to get the Declaration through, and the whole idea of the American Revolution going, and the Southern states to support it, North and South Carolina simply would not have come along without conceding slavery to them. The international slave trade was abolished in the Constitution, but that's about it. The Bill of Rights initially in our Constitution applied only to the federal government. So states could have established religions, states could do censorship, states could have slavery. And before the Civil War, when the Civil War happened, we got the 13th Amendment that said, no slavery in any state. And to enforce the rights of the newly freed slaves, they put in a 14th Amendment that said no state can deny any person within its jurisdiction the privileges and immunities of the citizens of the United States. Now, what that originally meant was the entire Bill of Rights now applies against all the states. That's what they meant. That's what they meant. They also said no state can deny equal protection of the laws to the people within its jurisdiction. Okay, that was turned into separate versus equal by the Supreme Court in 1892 in the Plessy case. The Privileges and Immunities Clause was gutted equally by the Supreme Court, saying, no, it didn't apply the Bill of Rights against the states. So the Supreme Court, in what in my view was total judicial activism, ignored the plain meaning and intent. If you go listen to the drafters of the 13th and 14th Amendment, this was their intent. That was completely ignored. So the intent of the framers, the plain meaning of the framers, was completely ignored by conservative justices in the late 1800s. So through the course of the 20th century, piece by piece, the Bill of Rights, a case-by-case basis, has been applied against the states bit by bit until now. Practically the entire Bill of Rights now can be enforced by the federal courts against the states. We changed separate but equal with Brown versus Board of Education in 1954. Obviously, that was a gross violation of the 14th Amendment, but it has only taken, and using the Due Process Clause, mind you, they didn't use the Privileges and Immunities Clause because they gutted that, the original mechanism by which it was supposed to happen long ago. So now the Due Process Clause is taking on all this weight that it was never intended to have from the 14th Amendment, enforcing bit by bit pieces of the Bill of Rights against the states. And that's the situation we're in, alas.
Well, that seems like a mess that we can't really pull ourselves out of anytime soon.
Well, one day my hope is that just as we have corrected separate but equal, so we can correct the Privileges and Immunities Clause. You know, we misdecided that case 150 years ago. The plain meaning of the words and the original intent of the framers was clearly to use the Privileges and Immunities Clause to enforce the entire Bill of Rights against each and every one of the states. So the relationship between states and the Constitution changed with the Civil War. Now, legally speaking, it's taken decades for that to actually catch up to be the reality.
I'm still frightened and don't have much hope that we're going to get there in our lifetimes. Robert Nasir with $5. Happy birthday plus a day. Mark P., thank you very much.
Yeah, happy belated birthday, Mark.
Thank you. I'm 29. It feels great.
Yeah, and you're looking good for a 29-year-old too.
29 for the 29th year. And thanks for the episode. It's hard to fight both left and the right, but that's what we've got to do indeed. And Catherine for $1.99. Thanks, Catherine, for all your support today. Yes, American Capitalist Party. Yes. Okay, from your lips to Dad's ears. Tom Koziol gifted one Ayn Rand Center UK membership. Thank you, Tom.
Thank you, sir.
So where do we go from here? We can't get a constitutional amendment to change any of this. What you're hoping is that there's a philosophical shift in the Supreme Court that reverses a lot of these decisions and puts the Constitution back on track. But will that happen in our lifetime?
I don't think we need a lot of amendments. We really don't. There's a couple that I might suggest that would help clarify these very matters, but take the First Amendment's freedom of religious exercise clause. When the framers said, you have the right to practice your religion any way you like, what they're basically saying is you, Mark, are free to act on your judgment and your beliefs in any way you like. You're free. It's a general freedom of action clause. The freedom of religious exercise clause says there should be nothing between your mind, your judgment, your beliefs, and the way you can act. Right? So until you say, wait a minute, that can't mean violating someone's right to life, or I can't punch him or kill him or steal his property. Right. So now we need to look at that will compel us to look at all the rights in the Bill of Rights as a unity based on the right to life. Absolutely. But if I was put on the Supreme Court, I don't know how long I'd last if they put me on the Supreme Court, I would obviously say it's the Privileges and Immunities Clause, that it must enforce the entire Bill of Rights against every state out there. States don't have rights. And I would also say just this. I would but I don't think I'd last very long on the Supreme Court.
I don't think you'd make it through the process.
The approval process.
The Senate would knock you out or something. Right. The race. Unfortunate for us. What was I going to say? I was going to say
how we get out. There are philosophers like Tara Smith, a great academic moral philosopher who's making great arguments this way. And we need academic philosophers talking about morality, and we need legal scholars like the late, great, my constitutional law professor, the late, great Bernard Segan, who wrote such books as Economic Liberties in the Constitution, or the Supreme Court's Constitution, which very much discusses the history of the Constitution as I have just described it. He very much understood what had happened to the 14th Amendment. And so there are legal scholars out there who were and are doing the work. There are moral philosophers out there. But man, do we need to re-educate people about what the Constitution is, what its intention is, the meaning of its words really are, if we're going to make the kind of progress that I call for. I mean,
this might be a little inside baseball, but what do you think of Joseph Story?
Joseph Story.
Have you ever read? I think that's the justice who wrote about John Marshall and wrote about the interpretations of the Constitution from that perspective. I think he was probably a Federalist.
Yeah. I do believe that, and Jefferson disagreed with this, but one of the things Jefferson got wrong, I do believe that Article 3 of the Constitution, which Jefferson wasn't involved in drafting, does give judicial review power to the federal courts. I think Marshall was not overstepping his bounds with Marbury versus Madison. Now, on the other hand, this does not give federal courts carte blanche to interpret the Constitution any old way it wants. By the end of the 19th century and the beginning of the 20th century, you think that they're hostile people to Jefferson today? There were hostile people to the founding fathers then. Oh my goodness, we can't be wedded to these free speech, freedom of religion. Oh my goodness, I can't do that. The government has to be given much broader scope. Progressives who wanted all this progressive legislation, wanted all these administrative regulatory agencies, realized that their primary enemy was an interpretation, the old way the Constitution was written and interpreted. Take separation of powers. The Madison said, no, the legislation has to happen by this group, and that has to be separated from the people who enforce the law, and that has to be separated from the people who adjudicate cases. Let's take the Food and Drug Administration, which gives us the abortion pill. They make the rules, they enforce the rules, and they adjudicate the rules. And in the 1950s, the Supreme Court had to basically chuck the separation of powers as a principle in our Constitution in order for these vast federal regulatory agencies to do what they do. I don't care if it's the FCC, the FDA, you can just go right down the list. These are all corruptions which are inconsistent with our Constitution. And so progressives for over 100 years now have been arguing that everything Jefferson said is wrong, because they realize it is the main obstacle to their socialist dreams and to their dreams of controlling thought through forms of censorship, which of course it is.
So it's very important that they malign him and soil his reputation for all eternity, because he truly is the founder that upon whose shoulders we all stand for real. If we want to hold our liberties, we don't want to be enslaved again. Mary Aline for $5. Thank you very much again for your great support this episode. Well, fantastic. I mean, I'm a little bit clearer on this terrible episode in Texas. May she rot in hell forever until she resolves this issue properly. Look, All we can do as objectivists is carry the message out there to the people and say it as rationally and cleanly as we can, so that non-objectivists pick it up and say, that sounds pretty good to me. I think I'm going to think about this now and maybe read a little bit of Ayn Rand and fortify myself against the coming storm, because I think there is a storm coming, and it's been caused by the political class. They like us to be at each other's throats like this. It distracts us, and it keeps us busy while they continue to grow their power. It sounds a little conspiratorial, but I think that's the way things go. I have some upcoming shows here at 9 p.m. UK time, HBTV with Harry Binswanger. Does money have a future? Well, given now that China's trying to occupy the heights of the dollar, and given the fact that they're trying to take the dollar into a digital currency, and I have questions about that myself. I don't think the people in command understand what money is, what it does, and I don't think the people understand how it contributes to their freedom to have real, tangible money in their hands, as opposed to this digital currency stuff. Well, James, as usual, it's been a joy.
Always, my brother.
Yeah, man. I love this. We have to do it all the time. Otherwise, I'm going to throw a tantrum and make sure it happens more. I have one more super chat before we bid our audience adieu. Daniel is sending it to me through the ether as we speak. Here it is. Catherine again for $4.99. Thank you, Catherine. Mark, want you to know I've resolved my issues with Jefferson. Very good. You should resolve your issues with Jefferson. He was a great man. Also, there is a book. There is a book by Mary Gabar called Debunking the 1619 Project. If you want to get into why Jefferson was mum on the issue of slavery, as not mum, because he clearly tried to pass legislation against the slave trade, and clearly wrote ideological sticking points with respect to rights that have been the inspiration of nations all over the world. But he was conservative about it with respect to himself as a public figure, as a politician who represented Virginia and the United States of America. And he had to take a very delicate personal position with respect to that. And when you read the details, it will start to plow through some of the myths of him as a racist jerk off,
right.
Slaveocrat.
In a context where most of the world had slavery, he was doing his best to eliminate it and mitigate it and reduce it. And it's funny that one of the great heroes against slavery in history should be tarred for owning slaves. Now, owning slaves isn't a good thing. Why not go even further? Jefferson wasn't perfect philosophically by any stretch of the imagination. He was no objectivist. On the other hand, he did more to eliminate slavery than just about anyone before the middle of the 1800s did in all of human history. So they've got it all upside down on Jefferson.
They truly did. And provided an articulate platform that enabled abolitionists to ground their own arguments. And he really is being vilified in a way that is most unfortunate for this country. If this country rejects Jefferson, they reject Americanism, and they reject everything good that this country is founded on. What's that?
As I recall, Martin Luther King quoted both Lincoln and Jefferson. Just comes to mind.
Stop. And also the great Frederick Douglass. If you want to see somebody who had deep respect for the founding principles of this country and for the Constitution, also a much maligned document by the left, read Frederick Douglass. Read
Up from Slavery. Do yourself the great selfish favor of reading Up from Slavery. It is one of the most inspirational things you will ever read in your entire life.
He was a great man. I consider him, to be perfectly honest with you, as a second founder, in the sense that he held the founders' principles, their feet to the fire, and he made America conscious of its paradoxes, and he did it in such an articulate way that it couldn't avoid them anymore. Or if you avoided them, you had to do it by such an obvious, glaring, logical leap that you were clearly on the wrong side of history. I
call him a founding father because he helped get through the 13th and 14th Amendments, by the way, that I was speaking of earlier. So he is a superhero who did help shape America as it is today. in good ways. So yeah, he is like the founding fathers.
Read his autobiography, read the 4th of July oration. They often quote the part in that oration where he takes America to task for its hypocrisy, and they leave out the second part of it, which is a very, very important part: his respect for the genius of the American system. You cannot deny that as a part of Frederick Douglass, which is why I think, really expansive rights respect. I mean, Martin Luther King had a whole host of paradoxes going on, but there's a reason Martin Luther King and Frederick Douglass are being pushed to the side of American history. They were consistent in their respect for human rights, and they understood it in a way that the left absolutely does not. And that's why I wouldn't trust a constitutional amendment today. Since the second Bill of Rights was passed, with spiritually speaking, with Roosevelt, and the UN Declaration of Rights, people's understanding what rights are so obfuscate the issue that I don't think we could get 3/4 of the states to agree on an amendment that would further our liberties.
Not now, not now, not now. No amendments, no conventions now. But you're absolutely right. Individualism is the only opposite of racism. And our consistent leftists and our consistent rightists are, of course, both different variants of racists. Because the only alternative to racism in some form is individualism. Promise.
Which we've been saying for a long time. Catherine, I'm glad you're not dumping Jefferson. Embrace him. In fact, I mean, yes, he says things that are wrong. He's a man of his times, but in many respects, and in some of the most important respects, he is above his time, and he's in our times. And what he says resonates through the ages as true and good, and you must grasp it. Our lives depend upon it. All right, again, I'm going to bid you adieu, James. Thank you very much. It's been a fun show, and I will see you next time, my friend.
A bientôt, mes amis.
And until then,